Welcome to everybody to this final session. We have an excellent panel for you. Before we start, I'd just like to say, in the words of Bruce Springsteen, it's been a long time coming. And as far as legacy is concerned, I'd also like to quote him and say to our successors, wherever they are, if I had one wish for you in this godforsaken world, kid, it'd be that your mistakes will be your own. In other words, do not repeat the errors, but inherit the good side of the legacy, and particularly that of the ADC. The other thing I would like to say is please sign and ratify the Anti-Slavery Convention. Those of you who have been working here for nothing, for long, know what I'm talking about. This institution could not function. The judges could not function. The registry could not function. The OTP could not function. And God knows the defense could not function, but for the unpaid labor of our wonderful interns, to whom I would like to pay tribute. And while we do laugh at that, the fundamental issue that everybody has to understand moving forward is that if the project of international criminal justice has a future, if it has a future, then justice is only going to work if you pay the price for it. The money has got to be found to make these institutions work properly, work effectively, and work honestly. That said, thank you particularly to Isabel Disterhoeft and to all of those who have volunteered their time and energy to put this remarkable event together. And thank you to all who make the brilliant ADC newsletter possible, again with Isabel's current editorship and of course before her Dominic and all of the wonderful interns, most of whom are on my team, who have been absolutely brilliant in putting together one of the most valuable resources in international criminal law. Now I think I've used up my time, so with thanks seriously for that, it falls to me to introduce, and I'll give all of the introductions now so you don't have me jumping up and down in between. Colleen Rohan, who will lead off, who, when I was asked if I would become standby counsel for the Karadzic case, I said on one condition, and that's that Colleen Rohan joins me because I can't possibly do it without her. I've worked with Colleen for many, many years now. She's been a criminal defense lawyer, appellate lawyer extraordinary in California for more years than she cares to number. She has been here now probably for more years than she cares to number. Been counsel in Popovich, in Haradinaj, and now with me in Karadzic, legal consultant on Perisic. She was a founding member of the International Criminal Law Bureau, former vice president of our wonderful institution, the ADC, former chairperson of its disciplinary council, currently the ADC rep to the ICTY disciplinary board, and she edited the ADC-ICTY manual on defense developed practices, an invaluable resource. Okay, that's Colleen. She will speak first. She will be followed by Edina Rajidovic, who is a criminal litigator for more years than she will admit to. And she and I, in fact, were called to the bar in the same year, I see, 1971. Oh, I shouldn't have told you that, should I? Served as Deputy District Attorney in Sarajevo and as Secretary for Legislation of the Government of the Socialist Republic of Bosnia and Herzegovina. Since 1991, she's been running her own firm in Sarajevo. She's been lead counsel here at the ICTY in the Delalic Hadji Hasidovic and Boszkowski cases. She is defense counsel in Bosnia and Herzegovina, particularly in war crimes cases, and has served as secretary and president of the Red Cross of Bosnia and Herzegovina for many, many years. Co-founder of this institution, the ADC. She developed and drafted the ADC statute and has been a member of its training committee, the rules committee, the disciplinary panel, the advisory panel, and we are very privileged to have her here, especially today. Now, there's only one person that I know of who has been defense counsel at the ICTR and at the ICTY, and chief magistrate of Fiji, senior magistrate of Tuvalu, attorney general of Anguilla, has done court-martial work in the UK and Germany, has been a crime, civil and family practitioner for, again, more years, prosecuted and defended in the UK, and was also senior judge on the sovereign base areas of Cyprus. A circuit judge, a QC, and has more judicial experience than most of us have ever appeared in front of. At the same time, he is, of course, now a judge at the ICTY, before whom I appear every day, so I have to be nice. And he is the ultimate distinction, a judge in the ICC, and member of all kinds of things, which we won't go into now because it takes too long to enumerate. But we are very privileged to have, looking forward to the future of international criminal justice, the man to carry it forward from the lessons that we have learned in this institution here to the ICC, to infinity and beyond. So that is Howard Morrison, who will speak last and has to leave at 5 o'clock. So I'll shut up and let Colleen, please, be the one to lead off.
Hello, everyone. Let's see if I can position this reasonably. I've been given kind of a strange topic, in my opinion, which is the ICTY legacy, expectations versus reality, which is pretty amorphous. We all have different expectations. I know what mine are. We all have different realities, that's for sure. And so it strikes me as being a very subjective kind of personal topic, although obviously the intention here is to draw on a larger experience. So I tried to think of how to go about doing this in a way that would work. One would be to make a sort of a small analogy, and that's that when I give talks like this or when I'm in court, I tend to write out bullet points on a piece of paper, and I type them out on my computer, and it's all quite beautiful, and it looks something like this, perfect and excellent. And that's my expectation. Then I came here today and listened to everyone else speaking, and now I'm dealing with this kind of mush-mosh, I don't know if you can see, notes that I've written, which is reality. So maybe one analogy here is we have great expectations, not to steal someone's title, and the reality sometimes turns out to be a bit messier and more difficult. I think all of us with experience in the international, certainly in the defense of international crimes trials, realize that that has been the case. It's important, I think, also, since we're looking forward here, to have some sense of what it is that we want with all of this. And I think my topic, to some extent, allows for a broader view, which is, what is it that we want? Do we want to have war continue so that we all have these great jobs and we work with the free interns? Do we want that? Do we want to develop individual legal systems that work for individual countries? Do we really want the International Criminal Court, which frankly scares me quite seriously? It does scare me about how it functions and how things are being carried on there, although granted it's been there for 10 years. But The ICTY, an institution I am very proud to have been associated with and remain associated with, I think was well beyond one trial after 10 years. I hope that the legacy of the ICTY and the achievements of the ICTY will be taken up at the International Criminal Court. To date, I don't see much hope of that, but we'll see, and that's also a work in progress. I looked at the ICTY webpage as well to see what the goals were when this institution was first developed years ago, and they're quite lofty. I'll list only some: efficient, transparent international justice, peace in the region, justice for victims, creation of a historical record. Those are just some. And I think it's important when we look to the future that we pay attention to these words that we use: truth, justice, transparency, shared values, because these terms are not necessarily real. In my mind, I have a different definition of that perhaps than you do. And it's important, I think, that we learn to recognize our differences, not to fight against them, not to criticize them, but to recognize them so that when we sit down to speak with each other and to try cases together, that we start out understanding that we don't understand each other. But that if we recognize that, then we can move forward and develop a mutual understanding, which certainly has happened with the people I've worked with at the ICTY. I think it's been a valuable experience from that standpoint. Rather than expectations, I'd rather focus on what I see as the achievements of the ICTY, and I think they're formidable. And also, again, looking at it broadly speaking, the ICTY has proved that international trials in complex cases are possible. And that was something that people were unsure of. I know it was commented on earlier today. People were unsure of that when the institution started out. The ICTY has proved that can occur. We've done it. We have various views about whether it's been done fairly, properly. Again, individual debate, but we've done it. We've also proved, which I think is a more valuable lesson in some senses, is that the international trials are expensive and they're time-consuming. And I cite that as an achievement because that's also the reality. And it's something that the international community has to face. If we are going to go forward with this kind of system, it's important to understand that it will not be a good one. It will be, you get what you pay for. And if you're unwilling to fund it properly, you will have a system that suffers from that. It's something that I think it's important that we all pay attention to, and certainly the powers that be that are forming these institutions. We have developed, and by we, I say the ICTY, us as a group, as a community of people working together, a system of developing jurisprudence. This is a really important point. But I think we make a mistake if we assume that this will automatically be adopted by other institutions. I think it's already obvious that it won't be. There are efficient procedures that have been put in place at the ICTY, rules and procedures. I don't agree with all of them, but they certainly have been workable, debatable. The ICC, again, and I'm using the ICC as an example because this is the institution that in theory will adopt some of our lessons learned, appears to have turned their back on that, and there are difficulties because of it. We'll see how that develops. We also, and it was interesting to me, no one's actually commented on this morning in this sense, we have developed a functioning legal institution as an institution. There's a registry. There's a victim witness program. There's a court management people. There are translators. We couldn't function without the translators. We have amazing audio-video technical people who have worked with us for years. And I don't know if Rob Barsoni is sitting in the background. Yes, he's putting his hand over his face as I see him. These people watch us every day in court, every day. They've seen all of us perform in court. The amount of institutional information in the minds of the AV people who work with us is phenomenal. The amount of information we could learn from them about what we look like, if you're sitting in court scratching your head or whatever it is that you're doing, what's a positive way of presenting yourself or a negative one. This is a vast ocean of information, and I hope that the AV people will come forward and tell us about that in one form or another. We've talked about the defense function, and since time is so limited, I'm not going to discuss that, but I would mention that the existence of the ADC-ICTY is also a huge achievement. A group of lawyers coming from all over the world who do not know each other, who don't have many resources, who speak different languages, who were on different sides of a war, who don't know anything about the war, perhaps, in the instance of some of us internationals, not in that sense, somehow managed to pull together and create an organization. And if there's, to me, this shows hope for humankind to begin to overcome some of our more difficult problems. The reality now, to turn to the reality, I think, is that for any institution to develop and improve, it has to be open to honest criticism. And this is one of the concerns with the media case that was mentioned this morning, where a lawyer was disciplined for giving his opinion. Whether you agree with it or not is beside the point. His opinion about this institution, perhaps it was about this institution, perhaps it was about something else. We need to be open to honest criticism. That includes the defense function. We all make mistakes. And I think that is an important lesson to learn in the sense of how any institution improves as it goes along. Another reality, again, I'm not going to spend a lot of time on this because you've heard it this morning and this afternoon. The defense, for all its strides forward, is still excluded from many, many things. There was a conference in Sarajevo this week that the defense was not invited to attend, an outreach kind of conference. As an example, even after all these years at the ICTY, maybe we should have been there or not, but I think the bottom broad point is the defense is still excluded from significant activities. There's a continued lack of understanding of the function of the defense, and you will see this, or I see it. I know my colleagues see it when you go and speak with people, and they have no idea what you do as a defense lawyer. If your client confesses to you, aren't you supposed to tell the judge, for example? And this doesn't mean people are stupid. It means that they're ill-informed about what the role of defense lawyers are. And it's something that we all have to take responsibility for in educating the community. And also, when you see anger over acquittals, for example, this is understandable in terms of people who are the victims of the crimes at issue. That's something we can all understand. But as an institution, an honest institution will at some point result in some acquittals. This is something that the broader community needs to understand, and we need to do work there. Ethical codes. We've had ethical codes as defense counsel since basically the early years, certainly at the ICTY. We still function in a world where judges who, thank God, have been, for the most part, at least in my view, perfectly ethical. Nonetheless, there are not codes, binding codes. The Office of the Prosecution at the ICC enacted a binding ethical code for the first time on the 5th of September of this year. And we all know that there have been issues over there about the prosecution. It's incredible to me that it took 10 years for someone to figure out that there might be a need for a code of ethics. We also, I think, must face the reality that we don't necessarily agree on what the purpose of these trials are. Some people believe the purpose is to obtain justice for victims, reconciliation in the conflict area, to create a historical record that was mentioned, to obtain peace. I mean, all these things are goals, but the reality, at least from a defense lawyer's point of view, is the trial is to determine the guilt or innocence of the accused who's in the docket. That's what the trial is about. That's what the system is about. The reality also, as a result of that confusion, is that there are people who are, in my opinion, mistake institutions such as the International Criminal Court or even the ICTY as an institution that should function in some way as an NGO or a human rights organization. It's not. It's a legal institution. And the rules and procedures that are attached to legal institutions need to be enforced at our own legal institutions. One big gap in our process And again, we're developing, we're in infancy. The ICTY has existed for 20 years. Obviously, there will still be gaps, but is, in my strong opinion, the need for a third level of appellate review, of some kind of review when there has been a difference between appellate court findings in different cases, or even perhaps between different tribunals. If we're really going to go for this, if we're really going to go for a system of international criminal law that is a proper system, then we need a third level of review to resolve these inconsistencies. And for those of you who, certainly the younger people in the audience, I know I meet many younger people, and I'm privileged to meet them, who are coming into my world of practice very eagerly, looking at this new system of law with an idea that we have this settled system. We don't. And I think we need to just look at that and understand that as a fact. Each tribunal, each court has a different system. We share similarities, but procedures and rules are different, and walking from one court to the next can be quite an experience. I'm probably getting very short. 2 minutes. Well, that's not too bad. Having said some negative things and positive, I really would like to end on a positive note if I can, and certainly with a note of congratulations to all of my colleagues here in the defense bar at the ICTY, who I consider to be brave and committed, and in many ways some of the finest people that I have ever worked with. I think we hope that we have achieved justice for our clients. Certainly that's something that we've worked toward, but justice, like beauty, is in the eye of the beholder, and it's a very, very difficult concept for a large number of people to agree on. What I think is perhaps more to the point for our experience is that given the disparity in our resources, the disparity in our training, the struggles that we've had as defense lawyers to get together to work on our cases, the diversity in our backgrounds, the language difficulties, despite all of that, the reality is that my colleagues at the ICTY have set a very, very positive standard that I think proves that a well-informed, well-funded defense is the only way to assure that we have fair trials and equal justice. I hope that we have learned that lesson, and I think that should be everybody's expectation and everyone's reality. Thank you.
Good afternoon, honorable judges, learned colleagues from defense and prosecution, ladies and gentlemen. My topic is perception from the countries of the former Yugoslavia. And before that, I want to mention that on this day, November 29, 70 years ago, in the Bosnian town of Jajce, the ground for what became known as Socialist Federative Republic of Yugoslavia were laid down. On this day, the decision was rendered to build the state on the democratic and federative principle as a state community of equal peoples. And it is the aspect of equality that I would like to talk about today in relation to the legacy of the ICTY and perception from the countries of the former Yugoslavia. This principle of equality, which was disregarded and walked over during the wars of the 90s, made me think about whether, and if so, in what manner this principle reinstalled itself in the legal sense in what is now called the region, following 20 years of the work of the ICTY. Three major issues raised. Equality pertaining to the application of the substantive law. Equality pertaining to sentencing, and equality pertaining to access to evidence. The ICTY legacy pertaining to the development and clarification of substantive international criminal law is by now a well-established fact and one that is not disputed even among its critics. For example, law pertaining to crime against humanity has been recognized as a forming part of international customary law, and its content has evolved since World War II through the jurisprudence of the International Criminal Tribunal, mainly the ICTY. However, it is still only Bosnia and Herzegovina in the region that prosecutes crimes against humanity. When trying cases arising from crime committed during the conflict in the former Yugoslavia, both the courts in Serbia and Croatia applied their respective criminal codes applicable at the time of the commission of crime, which, reflecting the ex-Yugoslavia Criminal Code, did not specifically provide for crime against humanity to be prosecuted. Therefore, no cases involving charges of crime against humanity have been prosecuted to date, either in Serbia or Croatia. And that is despite the fact that the ex-Yugoslavia Criminal Code contained a blanket provision referencing the application of international law, which is noted by the commentary, permitted legal recognition of every new development in international law without requiring a change in the ex-Yugoslavia legislation. Artukovic case is a perfect example of that. Despite this, and despite the jurisprudence of the international criminal tribunals, in particular the ICTY, people of the region, both the victim and the accused, don't seem to be equal before the law. However, a recent decision of the European Court for Human Rights in Šimić against BiH case has the potential to set a new course for judiciary in the countries of the former Yugoslavia and to accept the jurisprudence of that court and of the ICTY. In that case, the European Court held that while the act in question had not constituted a crime against humanity under domestic law in BiH until the entry into force of the 2003 Criminal Code, those acts did constitute, at the time when they were committed, an offense defined with a sufficient accessibility and foreseeability by international law as crime against humanity, and found no violation of Article 7 of the European Convention. The equality issues, both for the victim and the accused, arise in relation to the sentencing as well. In early 90s, both Serbia and Croatia abolished death sentences prescribed by the ex-Yugoslavia Criminal Code for genocide and war crime, leaving thus the law applicable at the time of commission of the crime with 20 years sentence that existed under ex-Yugoslavia Criminal Code as a substitute for the death penalty. In BiH, however, the death penalty was abolished only after the war. Therefore, as opposed to Serbia and Croatia, at the time of the commission of the crime, death penalty existed as an applicable sentence for war crime and genocide. While the courts at the BiH entity level try war crimes cases on the basis of the ex-Yugoslavia Criminal Code, replacing the abolished death penalty with the 20 years of the sentence, the Court of BiH, trying war crime cases in the state level, generally acted on the basis of the new BiH Criminal Code, which envisaged a maximum sentence of 45 years. This was considered to be in line with the sentencing practice of the ICTY and with the view that the long-term imprisonment would be appropriate substitute for the death penalty rather than sentence of 20 years of imprisonment. Although the Court of BIH did apply the ex-Yugoslavia criminal code in several cases where it's considered the minimum sentence for war crimes prescribed by the criminal code to be more lenient to the accused than the sentence prescribed by the new code. It seems that this new practice be followed all cases concerning war crime and genocide. This shift is being triggered by the recent BIH Constitutional Court decision following the European Court for Human Rights judgment in Mektauf and Damjanovic case. This could lead to some balance in equality, at least for the accused, when it comes to sentencing practice for war crime and genocide in the region. However, other form of inequality could be depend. First, the person convicted by the ICTY would be considered as having much higher sentences than if they have been tried in the region. Second, a person accused or convinced by the court of BIH, for example, deportation as a crime against humanity, would, in accordance with the BIH criminal code and the European court decision in Šimšić case, be facing long time imprisonment up to 45 years, while his inmate who is accused or convinced of genocide would not be facing more than 20 years. Third, satisfaction of the victims as well as other purposes of criminal sanction, such as rehabilitation and other, would seriously be brought into question. Third topic of that speech is equality pertaining to access to evidence. One of the ICTY's major legacies for all the countries of the former Yugoslavia is for sure the evidence and documents in general collected by the ICTY during 2 decades of its existence. This enormous collection represents a highly important source of documentation not only for historian and academic purposes, but also to numerous current and future war crime trials in the region. Although it was far from easy for the ICTY officials to collect all these evidence, the ICTY said both authority and influence to obtain necessary documents from various sources, including many states and international organizations. The local authorities, and defense in particular, have nothing close to such a possibility. For example, the defense team in Bosnia and Herzegovina don't have access to the ICTY electronic system disclosure system directly, but only through the criminal defense section OCO, which not only has insufficient means and budget, but also, despite their best effort to assist the defense, don't possess in-depth knowledge of the defense case and can't do search of the EDS the way the defense team members could. That indirect access to the EDS is possible only for the cases tried before the court of the BIH, and even that access is additionally restricted due to reduction of statement of person who did not testify before the ICTY, but did provide the ICT OTP investigators with their statement. Due to reduction of such statement, OCO is not available to locate them through the EDS. When it comes to access to various military, police, and other official state documents, a two-level problem arises. One concerning access to document and archive with the one state, for example, military archive in BH, and one concerning access to archive of the different state, for example, from Bosnia to Croatia or Serbia or vice versa. For example, as a defense counsel in several war crime cases before the court of BIH, I have been waiting for a year and a half now to gain access to the archives of the Military of Defense. The Minister of Defense is refusing defense access to such archives, even he didn't follow the orders of the court. And they explain that is confidential material, and according to the law to protect confidential materials, they refuse us. Finally, we need to raise the criminal reports against the Minister of Defense for not respecting the court orders. Given the problems to access the archives within one state, you can imagine what kind of mission impossible team would have one need to gain access to the state archives of other countries in the region. It is also important to note that some countries in the region possess official documents originating from military structure outside their own states, as an example, HVO archives, which are not to be found in Bosnia and Herzegovina, but in the Republic of Croatia. The defense does not have means to access another state's archive, not to mention access to NATO archives, UN archives, with all its Brit-Bat and Dutch-Bat archives, UN OSCE monitoring mission archives, and the list goes on. Therefore, in addition to question on equality arising from application of substantive law and sentencing practices, an important issue of equality pertaining to access to evidence exists as well. Enormous amount of documents from all those archives are to be found within ICTY archives. It is thus of critical importance that the legacy of the ICTY is and remain available to the parties in war crime proceedings conducted in the countries of the former Yugoslavia, and that is to both the member of the prosecutor and defense equality. And finally, one of the major legacy of the ICTY, in my opinion, is therefore the respect of the principle of equality that apply both to the accused and the prosecution. It remains to be seen whether the same equality will be achieved in the region. Thank you.
Research in California, where else, has apparently indicated that 10% of you will remember what I say for 48 hours, 20% will remember for 24 hours, but the remaining 70% of any human audience simply sits there immersed in its own erotic thoughts. Now, that's something of a comfort, because what it means is that statistically, whatever I say, the majority of you are going to be enjoying yourselves. Future challenges. Actually, the future challenges are pretty much the same as the ones we have at the moment and the ones we had from the beginning. The big one is going to be for defence, as ever, austerity. And I look at the UK and I see that in a time of austerity, legal aid is one of the first casualties. The implications of cutting legal aid are not just budgetary. They are, of course, go to the core of the importance of the defence and the importance which is given to the defence in criminal proceedings. And no doubt that the Crown Prosecution Service in England will also be suffering budget cuts, but that doesn't help. The other big problem, which I think is actually going to get worse and not easier for defence, is cooperation with or by hostile states and institutions when it comes to seeking witnesses or documentation. It's never been easy, and sometimes it's been downright difficult, and I experienced that myself, particularly at the ICTR, trying to get documentation out of some reluctant governments. But to resolve those issues, there's no magic wand. It requires two things for defence counsel. The first is an ethical determination to get the job done properly, and second is professional persistence. Don't take no for an answer. Just keep on going. You do, as I found out, get there in the end. But I foresee some new challenges and indeed opportunities. One of the big challenges that we face, it's not so much going to worry me at my age, but it's going to worry some of you, is the increasing world population, because the increasing world population is going to have a knock-on effect of international criminal law. Why? Because it's going to lead to more conflicts. We've always had religious wars, ideological wars, territorial wars. We've probably had an oil war. I suspect we're going to have water wars, food wars, diminishing mineral resources wars other than oil, and space wars. What do I mean about space wars? I don't mean outer space. I literally mean space. While we've always had territorial wars, it has not been generally so that one population can move en masse into the territory occupied by another population. It has happened. But I think as the population expands, that the pressures on those countries which have large unoccupied areas, and I'm just taking this as an example, Australia is going to come under pressure, as it is already under pressure in some ways, of immigrant populations wanting to move down from an overcrowded Asia. And so those things are going to become more acute. As those things become more acute, conflicts, both internal and external, will become more acute, and the resolution is going to be by law, and either international law applied domestically, for instance under the complementarity provisions of the ICC, or international courts and tribunals. I don't think the age of the ad hoc tribunal is dead. I think it's dormant. The fact it's still being talked about in terms of Syria, I think, is an indication of what may come in the future. Now, the other thing which I think is going to be problematical is that the euphoria that was around in 2003 when the ICC was set up and the honeymoon period that followed is over, and we're now into the marriage, and 50% of marriages end in divorce. So there's a lot to be done to maintain the marriage. It comes that the problems with the ICC and the African Union come as no surprise to me. There was always going to be some problems. What was a bigger surprise to me, and I was at the PrepComs back in the early 2000s in New York advocating for the defence to be an organic part of the ICC. The big surprise for me was that so many states that one didn't expect to sign up for the Rome Statute did at such an early stage. That was very encouraging, but it was inevitable that sooner or later people were going to sit back and contemplate and realise what they actually signed up for. And no immunity means just that. And I think that's sinking in. It's not simply in Africa that it's taking time to sink in, it's sinking in other places too. There are illustrations of that, even in my own country, the UK. 10 years ago, I would have thought if anybody had suggested that members of government might seriously be talking about withdrawal from the European Court of Human Rights, I would have fallen about laughing. I said it's never going to happen. Well, people are seriously talking about it. The realization that there are these rights which are becoming unpopular on an individual basis is setting in. Now, it's not to say there aren't faults with the European Court of Human Rights. There are faults in any judicial institution, and some of the reasoning and some of the judgments may not appeal to everybody. But the point is this, that once you've signed up for something which is in itself of merit, then it seems to me that you adapt the society to the merit. You don't get to adapt the society to the demerits of making life easier. And so I think the move that I perceive that will come away from individual human rights to community-based rights and more narrow nationalistic perceptions of things like extradition and immigration are going to create real challenges for international lawyers in the future. But as I say, that means opportunities. And it seems to me that two of the big things that are going to arise in the future, and if I was a young international lawyer I'd be looking at very carefully, is environmental crimes and transnational corporate crimes. Often those two will be interlinked. I'm not going to say that they will necessarily reach the level of a crime against humanity, although one could see how they might. But those are going to be areas which are going to be both national and international, and I think should excite the academic interest of young lawyers. Wise at least to investigate it. There are a limited number of opportunities for young lawyers at the moment in, for instance, the ICC. But look sideways, there's also the NGOs, there's also an enormous amount of international work now in government, which there never used to be. International law was hardly a feature of government departments 20 years ago. Now it's a significant factor, and it's something that young, bright people should be looking at. Now, some of us here are the past, and we're still here in the present, but not many of the older ones are the future. The younger people here are the future. You can do it. You can do whatever you want to do. Just keep going. Don't take no for an answer. And if at the first hurdle you fall, pick yourself up, dust yourself off, and go for the second one. Do not give up. You can have an extraordinary career through international criminal law. I came across it almost by accident, and I'm very grateful that I did. I'd lost all academic interest in law until I came into international law. It was simply a method of earning a living. It was only when I got back into law through international criminal and humanitarian law, and I realised how important it was and how important it's going to stay, that it grabbed me again, and it's obviously grabbed most of you, and that's a very good and healthy thing. You don't have to have done everything by the time you're 20 or 25 or 35 or 45. There are no time limitations on success. You just go out there and do it. I'm always astonished about the quality of the young people that interface with me at the ICTY and at the ICC. People with enormous talent and enormous brains. You're going to make a difference because you're going to have to. This world is getting increasingly difficult, and we learn about it increasingly quickly. 20 years ago, if something really bad happened in Syria, we might have heard about it 3 months later. Now, we hear about it like that. Ideas spread quickly, trouble spreads quickly. It's going to be international lawyers like you, and defence lawyers in particular, who are going to make the difference. So go out there and make a difference. Thank you.
Thank you to all three of our excellent and very provocative speakers. I don't know how much energy all of you have left. I do know how much time we have left, which is that at 5 minutes past 5 we get off the stage and hand over to Mr. President. But I think you'll agree with me that we've had some very interesting issues raised here. Howard has demonstrated that you don't have to have done it all by 25. In fact, he has not done it all, and he's not yet 65. So he's got a bit of a way to go in the field of international criminal law. When we, as a small group, sat down to say, well, isn't it about time that we had a defence perspective on the legacy of these tribunals instead of everybody else going off and having their little parties around the place? We said, well, we should plan big. We shouldn't simply aim to do one conference in The Hague, which will basically appeal to an audience of a few of us who've done it, a few of us who've had the experience, and a bunch of really enthusiastic interns who are wondering, how the hell am I actually going to get a job? What we should do, if we really are concerned about the legacy, is not just look at what have we done, what contribution have we made to the development of international criminal law, but we should look at what Edina has said. What have we done to the region, as we generally call it these days, the former Yugoslavia? What has been the impact there? How has it been received there? Colleen touched on this, and Edina gave us some very interesting assessments. And what we said when we sat down over a year ago to plan this was, well, we shouldn't just do it here. We need basically a travelling roadshow. We need to take this conference to the people who it most affects, who this law most affects. Well, as you have heard, we couldn't raise the money, with the exception of the Erasmus Foundation, we couldn't raise the money to do anything more than this. And I think that's a tragedy, because money can be found to send other organs of this institution to the region and talk about the legacy there. But the pit of misunderstanding into which so many people fall when they see people being acquitted that they don't want to see acquitted, and they don't have any kind of sounding board to discuss with us and to hear back what the reasons for that might be, so that they could say, okay, all right, I can understand that. The fact that that isn't happening and isn't going to happen, I think, is a minor tragedy in all of this. So, equality, even within those countries most affected, equality of approach is not experienced in relation to war crimes, crimes against humanity. Austerity, what is going to be its impact on justice as a whole, not just on the defence function? The future criminal areas that we all need to be thinking about, as Howard says, environmental crime, transnational corporation crimes, territorial conflicts, resource conflicts. What contribution do we as international criminal lawyers have to make to that? So with all that, questions. The mics, you know where they are in the centre, so please bring it on. Or, of course, not. All questions answered? Conference fatigue? So anyway, please announce yourself and your question.
Yeah, I have a specific question for Mr. Morrison. First, I'll introduce myself. I'm a master's student from University of Groningen, and now doing an internship in the Kaladzic standby team, defense standby team. And my question would be, I'm curious about, we have judges from different countries and with different background, of jurisdiction. And do you ever meet some situations like you have like conflicts in deciding some of the issues? And when meeting such conflicts, maybe this is not really a conflict or just different ideas. What do you think of that? And how do you deal with it? Thank you.
No. The short answer is yes. When you get people from different backgrounds. When I first came to the ICTY as Defence Counsel, I wanted to do it the English way. People who had trained in Scotland wanted to do it the Scottish way. People who had trained in America wanted to do it the American way, and so on and so forth. And civil law practitioners looked at things rather differently. They didn't. Oral advocacy was subservient to written opinions. So yes, of course, there's a different, and it comes to the judges. And in the early days, the common law judges perhaps were reluctant to enter the arena so readily as the civil law judges, and the civil law judges didn't really understand cross-examination. In fact, some of them didn't like it at all. I remember a judge from a civil jurisdiction going to watch a rape trial in the Old Bailey in England and left after 10 minutes shaking his head and saying, "Trop brutal, trop brutal." The pity was he'd only actually been watching the evidence in chief. He hadn't seen the cross-examination. And that's a true story. I was there. But yes, of course you do. But one of the great things about the system is that you learn from each other and the approaches. And as is well known, I sit with judges from South Korea, from Trinidad and Tobago, and from Italy, and we all have different approaches, and we all learn from each other, and we sort of feed off each other's experience. So it's a very valuable, if it's a problem, it's a very valuable problem.
Again, the question will be to you, Judge Morrison, but anybody else, feel free to jump in. Those of us who have been around for a fairly long time in these cases see that judges not only come from different legal traditions, but some of them, although professional judges, have never judged a case before in their life. They may have been to court one time, perhaps to get a divorce, but other than that, they were never in the court. They're diplomats or they're academics. They come from different legal traditions. And I remember once asking Judge Malotto when he came what sort of an orientation that he received. And I recall him saying, well, I was given a robe, the statute, the rules, and shown the courtroom and said, okay, there you go, start. My question is, after all these years, why is it that you see this disparity in experience in the judging? And what can we do, at least for the ICC or other tribunals, to ensure that when you go to one courtroom versus the next courtroom, you're going to see the same process. The evidence is going to be, adduced in the same fashion. We didn't see that at the ICTY, and there is a perception, an unintended perception that may arise out of that, in that if you have, at least at the ICTY, you had a group of, say, one ethnic group being tried by one particular set of judges from one particular legal tradition, and then, say, another ethnic group and what have you. And the perception was that you get different standards of judging. And somebody watching back home may be thinking, well, this group of people is getting more rights than that group of people. Now, that's not the case. It's never intended. But what can we do? What can we learn from the ICTY and pass on to our brothers and sisters at the ICC so that we can have some standard judging and a better approach to selecting judges who are real judges, real professional judges, as opposed to an academic or a historian or a diplomat?
Thank you, Michael. I understand these are now working. Is that right? Yeah. Yeah. Okay.
Well, as it was addressed to me, I agree with you, Michael. You get different standards of judges in domestic jurisdictions as well, of course. I mean, I sat in the UK in Birmingham Crown Court, was there 20 courts sitting, and you could go from one court to the other, and you'd get a rather different impression, depending on the nature of the judge and the nature of the case. So I think unless all the judges are made in the same factory, that's what's going to happen. But you're right, the selection of judges for international courts and tribunals needs to be tightened up, and there is a committee to do that for the ICC, to investigate those who have been nominated by. I mean, there are, some judges who come with a wealth of coalface experience, and some who don't. And when it was done in public, I don't mind repeating it. When I was in the elective process for the ICC, which is a pretty miserable process, I can tell you, to go through, I figured out I'd done more cases in the criminal court than all of the other 18 judges combined. And it shouldn't be like that. It really shouldn't be like that. So you get people with hardcore experience of criminal cases, such as Lord Bonamy, such as myself, but you have a lot of people who haven't. And it's the selection process that's got to be looked at very carefully. And then a training process thereafter. And one of the things that I am involved in is looking at the potential for training for ICC judges. But you have to tread very carefully. There are egos out there.
I think we have another very experienced judge who may be offering us a view on that, Judge Malota.
My view was going to be just on a little point that Michael touched on with respect to the ICTY on how do we reduce the conflict between judges coming from different jurisdictions. When I first came to the tribunal, it was an observation I made that no trial chamber was composed entirely of common law judges or entirely of civil law judges. There was always a mixture. I must confess, now lately I noticed that there seems to be a departure from this practice, perhaps because we again winding down. Again, it's not just civil law thing that comes in, but it is also language, English and French, as official languages of the tribunal. I say this because if you look at, for instance, Judge Antonetti's chamber, it's all civil law. Now that's the change that one sees. But in the beginning, and who am I to talk of the beginning? I'm a baby at the tribunal. When I came into the tribunal, that was not the case. That's all I wanted to say. Thank you.
Thank you. Professor Brianne McGonigal, I think you had a question.
I did. Hi, thank you. My name is Brianne McGonigal, assistant professor from Utrecht University. Thank you for all the presentations, not just in this panel, but for the entire day. I think I can speak on behalf of everyone here saying it's been a really wonderful conference. But the title of the conference has legacy in it, and that's what my question is about. This has been a wonderful conference, and we heard that there wasn't enough money to take it to the region, but what other alternatives have been thought up so that there is a legacy of this conference? Are there ideas that the panelists will be able to write something up and that perhaps something can be put on open access journals online or even newsletters? I'm interested in knowing what's the legacy of today, because I think that's really important. That if you guys can't make it out there, that somehow the information can get translated. I'm not sure, but that's my question. Thanks.
To the extent, is this working? Yeah, I guess it is. To the extent that I am aware, there will be a publication created that is essentially every word that was uttered while we were here today. Everyone, I think, notices that the AV people from the ICTY have been here filming every moment of the conference. I'm assuming those films will be available, although perhaps the AV people are in a better position to say exactly where or how and what the access will be. There has been a discussion of expanding on the publication of the word-for-word aspect of the conference to include papers on the particular topics that were presented. So various ideas have been developed, two of which I think are pretty much absolutely certain to occur. Definitely the legacy publication.
Judge
Novak,
Morrison
do you
has
have
to
more?
leave us. So.
I'm terribly sorry. Good luck for everybody. I'm sorry I have to rush off. The rumours that I'm attending a session of Alcoholics Anonymous are entirely false.
I think we've got time probably for two more questions if they're out there. Or alternatively, Vivian Dietrich.
Yes, hi, Vivian Dietrich, London School of Economics. I'd like to come a little full circle and come back to President Moron's keynote speech and the closing he made. So he said that I hope you know that the tribunal's legacy is very much your legacy as well, referring to the legacy of the defense. And I'd just be curious to have your impressions and experiences, kind of how much you see that there is that overarching legacy in terms of kind of the homogeneity, heterogeneity between parties before the proceedings, different actors, And yes, kind of in what way you see also within the defence community, within the Association of Defence Counsel, given different experience, is there kind of dissonance or consonance kind of about their own experiences and about the work of the tribunal as a whole? Thank you.
And before we take answers to that, are there any other questions from the floor? Okay. It's blinding here, so yeah, are there?
Hi, I'm Joris van Wijk from VU University. Just something I want to share and get your view on. I'm doing a research project on the question what happens to people once they are convicted. And for that we also looked into early release decisions, and I talked to some lawyers, and what actually I find striking is that it seems that all the lawyers who represent their clients in early release procedures do this on a pro bono basis. And I wondered if we can foresee any changes at the ICC in that regard, because I was completely shocked by that fact that years later on a pro bono basis you will represent your client. So if there are any views on that, I'd like to hear them. Thanks.
I have a view. I have a really strong view. That is that the defense is ridiculously underfunded, and this is one of the many areas. There are lawyers sitting in this room who have spent hundreds of hours dealing with post-conviction issues for zero money, and that includes expenses out of their own pocket to go visit their client wherever they may be incarcerated, and other issues, translation, a series of other things. If anyone here is aware of a case in which someone was paid for that, I would like to know about it, which is why I have to say the commitment of the defense in this particular world, the international criminal law world, to me is breathtaking at times, because we do a huge amount of work for no money. And it doesn't mean that we haven't asked for it. Part of it is a budgeting issue. Part of it is a failure on the part of those powers that be to appreciate that these issues exist. For example, that there will be post-conviction problems, aging defendants who need medical care, things like that. That this hasn't been thought through. I'm sure there's other people in the audience who will have comments on this who've had to deal with this in their world. I know some are here. But if you're shocked, we're shocked too, because we have to do it for free. And this is something that should be rectified. If the trials are so important to the world, the international community, that we are going to put them on video and broadcast them around the world, they are going to have political influence, have had political influence. To me, it's an absolute scandal that there has been a refusal to budget them properly.
The other question that was asked was about how what the legacy of the defence as the ADC is. I think that really has been addressed fairly substantially throughout the day, although due to my court commitments I wasn't here for much of the day. But Adina, do you want to say anything to that? No.
The legacy of the defense? I mean, if the question was, is the defense going to be entwined with the legacy of the ICTY? Was that the... I mean, we had to publish our own manual. We were at one point to be part of the manual the ICTY published, and essentially so many restrictions were put on the defense that we ended up, silver lining, creating, I think, a better product than we would have had we been limited to one chapter in the ICTY manual. We created our own. That's just one example of what I see as the defense bar's willingness to participate in an overall legacy, but our exclusion from that legacy. I'm not suggesting people are malicious or there's a grand conspiracy. I just think that there's a lack of understanding of the importance of the defense function and the defense contributions. I think if that understanding was there, some of this exclusion would no longer be occurring.
I think that is, to a great extent, our legacy, is that we have, with varying degrees of success, put that message across. I think, generally speaking, everybody gets it, as long as they don't have to go into their pocket and pay for it. And literally, it is clear that all of the judges, irrespective of their background and what they are used to in a domestic context, all of the judges see the value of defense advocacy and good quality defense advocacy as being integral to the public perception of this as a valuable institution. Because frankly, I've sat through now 3 trials, and I will sit here and I will tell, I wasn't going to say this, but I will sit here and I will tell you, defense rocks. Quality cross-examination, time and time again, and you do not see that in the same degree always on the other side. But Edina.
I said no, but I want to say something from my own experience. When I finished here, all these things that I learned here, that I act here, I put with myself in my country, and legacy of that tribunal and is my fight for the substantial law, for the procedural standard, for the right of my client in my courtroom. And my colleague learned from myself. That's also one of the very important things that I can do as a counsel from that tribunal to my own country, to my colleague in Bosnia and Herzegovina. That's something that I wanted to add.
I think, sorry, this must be the last question, but thank you.
My name is Alan Yatman. I'm a Philadelphia lawyer. And I just wanted to mention before we close that this presentation today was developed very much by the scientific committee, which is made up of Richard and Colleen and Stefan, who is left, and Annie O'Reilly, who did an amazing amount of work to think, and me, to think through this program, to think through these topics, to recruit speakers, all of whom have been wonderful today. And I just wanted to let you know that in addition to Isabel being our ramrod in helping us get this through, that these people put in dozens and dozens of volunteer hours on Skype, usually cutting in and out at the most important moments. And I want to thank my colleagues on the Science Committee.
With that, I think we're dead on time to hand over to Mr. President.
Well, let's start with less protocol. Dear guests and dear friends, I can say now, after so much time spending together. I think I made one mistake this morning, now listening to everything that's going on. It's from my own perspective and from my own experience. I said that this purpose of this conference is to share our experience with you. And I learned so many things today. Even I spent 14 years in this tribunal that I got some new experience today. And that this is something which shows what is international justice and what is experienced in international justice. I want first of all to thanks to all speakers again. I want to thanks to all of you who participate orally in questioning and giving your comments. Even I want to thanks to you who in your mind confront your view and your thinking with us and didn't want to use or didn't have opportunity to use the microphones. And that will be some kind of my last observed related to this conference. If any of you, especially young lawyers, somewhere in the future use one sentence or one thought of everything what you heard today, somewhere in your preparation, in your thinking, or in your real performing your act, somewhere in the courtroom, whenever position you take in the courtroom, then I think that we materialized this idea of this conference, and I'm really happy if you remember one day that what you heard for the first time here in this room. I want to thanks to ones who I forgot at the very beginning, to guys from technical support from tribunal who spent all day with us here, not in the courtroom. I don't know how it's boarding for them was this, but please say one thanks for the guys. And at the very end, we mentioned one name 3 times, and I think it's fair to mention one more time, Isabel. I know we have a problem with her last name, so I just want for Isabel, we have one small present. I want you all to see her. So I think I'm the one who, among other members of executive board and also the guys who work on preparation of this conference, we are aware really how many days, I don't know for nights, but how many hours and days and months she spent trying really to organize these things work. And I really, at the very end, happy, and I think that we did a good job because of her, first of all. Okay. You want to say something?
I want to say thank you to everybody who's here today. You've made this day very, very special. I've had a great time organizing this conference with an incredibly legacy committee, more volunteers that I could hope for, incredible people, and I've had a great time, and I hope you had as well. And thank you so much for everything.
And the last sentence, which you expected, I hope not for a long time, so I pronounce the end of this conference. I invite all of you to join us this evening after 8 o'clock of our annual party, which we made every year, and we really wanted to share with you this evening. Hudson Bar is just a few hundred meters from here. You're welcome to have a drink with us and to join together this evening. Thank you very much again. Hope to see you then.